1 to 4 and 6 to 7. Place for adjournment on the ground that the arguing counsel is unwell. List after 2 weeks.
Grateful.
Serial number 20, my lord.
The counsel for the appellant has no objection to the prayer for adjournment. List after 2 weeks.
My lord, serial number 20, my lord. I am respondent. I want to file my objections. I need 4 weeks time to file my objections, my lord.
Serial number 20.
Yes, my lord.
Who is for the petitioner?
I am for the petitioner, my lord. I have no objection.
Oh, yes. Mark the presence, Mr. Ramesh Upadhyay, learned counsel for the petitioner. K. Narayan Swami, learned counsel. Respondents, praise for him is granted.
Lordship, serial number 12.
22, my lord.
Oh, yeah, all of you are in a hurry. We thought, yeah, all right, yes, please. 22.
22, my lord.
Yes.
1 week may be granted, my lord.
No, you are appearing for petitioner.
A petitioner, my lord.
Who is for respondent? Yes, Mr. Government Advocate.
Serial number 19, my lords.
Wait.
Please.
On that.
What is this?
Next week, my lord.
The new year is unexpected with so many adjournments, right? At 10:30.
My lord.
No, we said that beginning to new year.
1 week, my lord. I read translation and judgment. Enough, sir. 22, my lord.
This is 2012 matter, Mr. Direct counsel for the petitioner. Praise for adjournment. By way of indulgence, hearing of the petition is referred. List after 1 week. No adjournment, list on the next week. Yes, next.
Permitted to mention one matter.
Your Lordship, serial number 27. 27.1, 27.2 connected matters, Your Lordship. I seek 2 weeks adjournment, Your Lordship.
First of all, you should tell us you are appearing for whom?
Respondent.
Have you informed the counsel for revenue?
Yes, Your Lordship, I have informed.
You informed Mr. Arvind?
Not inform, my lord. I'll leave to your lordships, my lord.
Yes, Mr. Arvind, what do you say?
Lord, not informed, but I'll leave to your lordships, my lord, so far as adjournment is concerned.
When she is praying for adjournment, so do you oppose the prayer?
Next week, my lord. Next week, your lords, my lord.
Yes, madam, please argue next week.
Yes, Your Lordship.
37.
Your Lordship.
KVR is learned counsel for the revenue. Right for me, learned counsel for respondent. Learned counsel for the respondent. Place for adjournment. List next week.
Your Lordship, I may be permitted to make one submission regarding serial number 29, Your Lordship. I'm appearing for the respondent. Your Lordship, my senior, Mr. A. Mahesh Chaudhary, had to go for a COVID test as his cook has been tested positive. I have informed the Revenue Department Council also regarding the adjournment, Your Lordship.
Next week?
2 weeks, Your Lordship.
Yes, Mr. Arvind.
Please, your lords.
Mr. Arvind KV, learned counsel for the revenue. Right her name. Learned counsel for response. Please for adjournment.
Your Lordship, serial number 31.
List after 2 weeks.
Grateful, Your Lordship.
Your Lordship, serial number 31. I am for the petitioner, please, my lord. It's a habeas corpus petition. Your Lordship, the detainees have been arrested formally, please, my lord. So I would request this court to dismiss it as withdrawn, please. Yes, please, my lord.
Learned counsel for the petitioner submits that subsequent to the filing of the writ petition, the petitioner has been arrested. He therefore seeks leave of this court to withdraw the writ petition. Accordingly, the same is dismissed as withdrawn.
Obliged, please, my lord.
My lord, may I be
Lordship, serial
permitted to
number
mention
19,
one
my lord.
matter, WP 21547 of 20.
Wait, madam. We have given 10 mentioning let us proceed serially now. It will reach 19 within.
Your time for petition is 19th.
Why don't you first? Why are you waiting?
For admission, chamber 1, CT,
But I appear for the appellant in this matter. Now, this is a appeal under Section 21 of the National Investigation Agency Act, not filed by the National Investigation Agency, challenging the order of the learned special judge, granting bail to 4 accused persons who are involved in illegal trafficking of about 38 Sri Lankans. Though order was passed in the first week of December 2021, the accused will not continue. I have made an application for interim stay. The accused will not continue to be in prison.
Not stay.
The accused will not continue to be in prison for the reason after the order on bail was passed, they made 3 attempts to furnish sureties with fake documents, in respect of which the learned trial judge is proceeding to register 3 different cases on these appellants.
No, we'll consider your prayer only after notice, not expert. Mr. Prasanna Kumar P. Learned Counsel for the appellant. Notice on admission as well as IA1 of 2022.
Please.
Chamber 2, the appellant
For the petition, my lord. For the respondent number 3 and 4. I'll say I filed the acknowledgement in the course of the day. Acknowledgement, I'll third it on the other side, my lord. The IA is third. Acknowledgement, I'll file it in the course of the day. On 16th December, my lords have dismissed the petition for non-prosecution. 9th December 2021.
Yes, who appears for their representative?
My appearing for the respondent number 3 and 4, my lord. I have no objections to what's it.
Not the presence. Hold on.
And directed to appellant, my lord, to serve the copy of the writ petition.
Petitioner submit that he shall comply the office objections during the course of the day. Heard on IA1 of 21. For the reasons assigned in the application, which is duly supported by an affidavit, order dated 9/12/2021, is hereby recalled in the result WP number 36942/2016 is restored to file.
Obliged.
Yes, sir.
Appearing for the responding, my lord.
One company and a shareholder for the second respondent company. The second company is also the shareholder. Some disputes have been resolved now. Amicably. There is only one submission, there is an office objection raised that how this OAC is maintainable. I am a party through and through. And because my name doesn't appear in the cast list.
Not audible, Mr. Counsel.
But objection has been raised.
Okay, please check your audio. It is not audible.
You are not audible. Please speak into the mic.
One moment. Am I audible now?
Your voice is not clear. There seems to be some error in your instrument. Your voice is not clear.
My lord, I am appearing for the respondent. The matter is settled between the parties, my lord, and filed a compromise petition and also joined memo, my lord, for withdrawing the petition, my lord. So maybe lords made.
So he wants to ask him whether he wants to withdraw the appeal.
If the respondent counsel says the petition is compromised, do you like to withdraw the petition in terms of the compromise?
There is no question of withdrawing the petition. I am saying that we have, my shares have been purchased by the state government for 68 crores. I have received the money, let the matter be closed. That's all. All that I am requesting for I should say is that kindly overrule that objection that the vote is not maintainable. Number one.
Are you disputing the compromise? Are you agreeing the compromise?
We have signed the compromise. We have signed the compromise and also we have a memo, a joint memo, saying all the terms and conditions have been fulfilled.
The terms of compromise dated 30th October 2021 can be accepted.
Please.
Yes.
Here.
That is the issue with regard to maintainability of the appeal. It's something.
The maintenance appeal. What about the maintenance appeal?
Millard, that is, Millard, the High Court, the registry has raised that we have filed, in any case, filed an IA, a third party IA, kindly allow that IA and overrule the office objection.
What is IA1?
IA1, Millard.
That is written.
No objection, my lord, because my lord, that's the application. The petition itself is filed by one of the shareholder, my lord. The OSA is maintainable, my lord. They file an application also. So I have no objection, my lord. The application may be allowed and compromise may be recorded. Please.
Heard on IA1 of 21, an application seeking permission of this court for filing leave to seeking leave to file an appeal. Full stop. We have heard learned counsel for the parties. Learned counsel for the appellant submits that the appellant is a shareholder, and therefore the appeal at the instance of the appellant is maintained. For in view of offensive submission, IA1 of 21 is allowed. The office objection with regard to maintainability of the appeal is over. Also heard on IA1 of 21, an application filed under Order 23, Rule 3 of the Code of Civil Procedure. Learned counsel for the parties submit that the dispute in this appeal has been resolved between the parties subject to the terms and conditions mentioned in the compromise. Full stop. It is further stated that compromise petition has duly been signed by the parties. Full stop. After perusal of the compromise petition, we are inclined to accept the compromise petition. The appeal is disposed of in terms of the compromise arrived at between the parties, which is reproduced below for the facility of reference. Clause 9 onwards, each schedule. Accordingly, the appeal is disposed of.
Millard, your lordships took the compromise petition on record, Millard, and also the joint memo. Joint memo. Very well.
We have taken on record and we have reproduced also the terms and conditions.
Very well. But there is a joint memo filed that Millard, the compromise petition was subject to certain conditions which have been Millard complied with subsequently by the parties, and they have filed the joint memo.
Then say it is learned counsel for the parties while inviting the attention of this court to the joint memo submitted that the terms and conditions set out in the compromise petition have already been
duly complied with. Yes.
My lord, there was an interim stay was there, my lord, on the utilization of the land, my lord, because of.
You know what happens when the.
Yes. Much obliged.
Please, your lordship. In this case, the petitioner has questioned the order of detention under the Karnataka Gunda Act. Additional grounds had been raised. In the view of it being a habeas corpus petition, strict rules of pleadings, etc., are not applicable. Your lordship may allow this application and hear the matter where this with these additional conditions.
Mr. Kiran S. Javli, learned senior counsel. So and so heard on IA 1 of 21 for the reasons assigned in the application, same is allowed. Let amendment be made within
2 days, my lord.
Within 2 days, learned additional government advocate praise warrant is granted a week's time to enable him to file amended statement of objections if so advised. List on which date, Mr. Next week, Mr. Javli.
Please, your lordship.
Which day?
1st or 2nd, your lordship.
2nd February. Next on 2nd February 2022.
Obliged.
Number 5, CM Lava.
May I please your lordship. May I please your lordship.
Yes, yes, Mr. Shankar. Yes.
It's been complied on 20th of last month itself. Unfortunately, the acknowledgement could not have been filed. I have filed it in the morning today, my lord.
Achha. Mr. Shankar Lalit, Senior Counsel with Mr. Lava, and submits that the office objection has been complied with. And the acknowledgement has been filed today.
Today, my lord. Today, my lord. Yes.
Acknowledgement has been filed today. Accordingly, the office objection is removed.
Number 6.
Please, your lordship. Matter arises under the Coffee Posa Act. They are ready for final disposal.
Appealing for the respondent, my lord. Appealing for the respondent. Yes, my lord.
Ready?
Ready, my lord. Ready.
All right. We'll take it up, Mr. Please wait.
Please, your
just finish the other matters and then we will take up your case.
Please, your lordship.
Number 7. Sharona S.
Lords, appearing for the petitions counsel in this matter, my lords.
Yes, Mr.
Lords, I have served the respondents counsel, my lords. Now the contesting respondents for the instant case will be, my lords, the 4th respondent and the 5th respondent, and 6th respondent is the authority, my lords, which is required to inculcate the seats in or counseling. Notes the facts leading to this case is that the petitioner being an existing 100 intake.
Ravi Shankar, there is some office objection, non-compliance, furnishing of process fee, etc. They have not been solved.
Lords, their names are not shown because I have already served them. Lords, the urgency is that the counseling has already commenced. Lords, the NMC, after inspecting, records a finding that I have the infrastructure and instructional facilities for 250 seats. But without assigning any reasons, it is approved only for 200 seats. Lords, I have this matter day after tomorrow, my lords. I will, by showing the name of, Lords, N.K. Ramesh appears on behalf of respondent numbers 3, 4, and 5.
Okay. Office is that Mr. D.R. Ravi Shankar, Lalit, Senior Counsel.
3 and 6.
Amidst that the copy of petition along with annexures has already been served on Mr. N.K. Ramesh, who
N.K. Ramesh appearing for 3 and 6. 3 and 6.
Who represents
and Ketty
3 and 6. Right?
3 and 6. And Ketty appears for 4 and 5.
As well as Mr. Ketty, who appears for respondent number 4 and 5. Office is directed to reflect names of so and so and so and so as counsel for respondents 3 and 6 and respondents 4 and 5. List on 27th January.
Lords, it will go to next week. Lords, the counseling is already commenced. If the seats are not inculcated, Lords.
Then tomorrow, please inform. We will take up tomorrow.
Not this matter. I have this matter tomorrow, Lords. I'll keep both of them informed.
Based on 25th January 2022.
Great. 27 next.
Your lordships, I appear for the petitioner in this matter, your lordship.
What is it?
Your lordship, the matter was listed on 20th of September 2019 and 4 weeks was granted for complying with the office objections. However, one of
grabbing, madam, hand grabbing. What is the petition?
Your lordship.
What is the prayer, madam?
Hand grabbing. Quite sure.
Now there is an appeal, right? Madam?
Yes, your lordships.
In the repetition, you seek quashment of an order dated 18th of March 2019, passed by Karnataka Land Grabbing Prohibition Special Court, right?
Yes, your lordship.
Now, by way of an amendment in the Act, an appeal lies, right? Whether that right of appeal is available to you.
Your lordships, I have to verify. I will
Before filing an application for recall, you should have verified, no? If an appeal lies, then we would grant the liberty to you. Where is the amendment? Mr. Natraj, Karnataka land web.
Your Lordship, I'll comply with the office objections if the order is recalled and then.
No. Yeah, just please see the act. Please review session 4. And there is a police for appeal. Where of amendment?
17 edition.
Mr.
Latest still one. 2017 amendment.
17 amendment. There is a provision for an appeal, no?
Yes, ma'am.
You know, madam. It has come into force from 19th October.
19th October 22.
So, madam, under section 17A of the Act.
Yes, your Lordship.
You have a right of an appeal. All I will list the writ petition tomorrow. Please examine it. Huh?
Yeah, obliged, your Lordships. I'm a proxy counsel, your Lordship. If it's listed tomorrow, I will verify and I will ask the counsel on record to make submissions.
Proxy doesn't mean that you can claim right to ignorance, right? Please see, we are telling you 17A has been incorporated by way of an amendment in the Act. It provides for an appeal. So we have passed orders in several cases. We have relegated the parties to remedy of an appeal, right? You have to file an appeal. So
kindly
have
have
your application. It will come up tomorrow or day after, whenever, right? 27. Word on IE 1 of 20. For the reasons assigned in the application will be supported by affidavit. You find that sufficient cause for conveyance of delay of 142 days in filing the without 3 is allowed, 2 of 20 allowed, order dated 20th September 2019 is recalled. Let writ petition be listed for order on 27th January.
Grateful, your Lordship.
Number 9.
Serial number 9, first matter. Mr. S.N. First matter, Mr. S.N. Prashant Chandra is appearing for respondent number 5. Therefore, kindly direct the office not to show my name.
That's kindly, please, my lords. Serial number 9, please, my lords. I appear for the respondent number 3 and 4.
Just a minute. Just a minute. But in the first matter,
and that day I was on leave, my lord. The Lordship's court officer only sent that. By mistake, he has not sent the wallet.
Why these cases have come up?
No, it is specially ordered, my lord, before your last one.
Validity, wires of the.
Now it is coming up before
Wires of
portal
the BWSS Act.
not before portal 1. Last week onwards, it is coming up before portal 6. Virus, challenging virus. But this is by special orders. It will come up before your lordship only. Before portal number 6. This is by special orders before your lordship.
Yes, Mr.
Virus, my lord.
In the first matter, my lord. In the first matter. Just a minute,
89A, please, my lords, of the BWSS Acts, please, my lords, 1964 is under challenge.
So,
pro rata, please, my lords, and beneficiary
that's all right.
contribution.
But yes, Mr. Yes, Mr.
I'm for
in the first matter.
He wants to say something.
Just a minute, my lord, in the first matter, Mr. S.N. Prashant Chandra is representing BBMP R5. Therefore, kindly direct the office not to show my name, my lord.
Where is Mr. Prashant Chandra?
Appearing for the Prashant Chandra, my lord.
Yes, madam.
Your lordship, my senior is not keeping well, my lordship. I seek for an leave surgery.
Next week, madam. Next week.
May I make one submission?
May I make one submission?
There are about 100.
There is an interim order in your favor. What's the problem, Mr.?
May I make one submission?
There are about 100 matters, my lord.
There is an interim order in your favor, right?
Yes, ma'am.
Yes.
May I, with my lord's indulgence, can I make one submission?
Yes.
My lords, my humble submission is about 100 petitions are filed totally, please, my lord, seeking to challenge the constitutional validity, please, my lords, as also the implication of the notification. And, my lords, the notice, my lords, calling upon, please, my lords, the various builders, please, my lords, to pay, my lords, BCC charges, pro rata charges, as also NOC charges. And now, please, my lords, as per the NGT order, there is this treated water for construction purposes. We are, my lords, charging that also, please, my lord. That is also under challenge. My humble submission is, please, my lords, the pleadings will have to be complete, my lords, in the later on petitions where constitutional validity has been challenged. I pray for about 2 weeks' time, please, my lords. I will complete the pleading. Second week, all these matters listed. I appear for BWSSB, please, my lords, respondent number 3 and 4.
Counsel for respondent 3 weeks time.
I for respondent number 5, my lord.
Hello. Malad, in the first matter, kindly direct the office not to show my name.
Office is directed to delete the name of Mr. K.
Let's can I request Mulats for a date and second week of February, please, Mulats, so that on that day it could be heard and disposed of. There is some urgency also.
So you first file objections, thereafter we'll see. You first file, we have granted you 3 weeks time, first file objections.
Grateful.
Let the pleadings be complete. Date can always be fixed.
Please.
10 also.
10 also same. 10 also. Interim order needs to be extended.
Interim order can continue. Yes.
My lord,
I appear for respondent, my lord.
My lord, serial number 11, my lord, appearing for the appellant. My lord, I seek most humbly adjournment for 2 weeks, my lord, because a very close relative of my senior is very sick, as well as several associates in the office have tested positive, and the office is not functioning currently, my lord.
For the petitioner pays for adjournment. Appellant pays for adjournment on the ground that the arguing counsel is under. Just after 2 weeks.
3 weeks, my lord. After 3 weeks or 2?
2 weeks. 2 weeks.
2 weeks. Public.
Number 13, CKV Arvind. Number 12.
Serial number 12, sir.
Number 12.
Serial number 12, I'm requesting for a week's time in this case, my lord. My wife is tested COVID positive. Slight inconvenience is there. It may be posted next week, my lords.
The counsel for the petitioner pays for adjournment. This next week.
Serial number 13, my lord. The questions, my lord, are page number 8 to 10. My lord, 4 questions are there. My lord, the first question, my lord, as of now, my lord, it is decided against me. Your lordship kindly consider to admit, my lord, only question number 2, 3, and 4, your lordships. At page number 9 and 10, my lords.
Hold on the question of admission. The appeal is admitted on following substantial questions of law. 2, 3, and 4.
Please, your lord.
Number 14.
Lord, serial number 14, my lords, this it pertains to transfer pricing issues, my lords. My lords have previously admitted a batch of matters, my lords. They framed the questions of law at page number 8 and 9. There's 4 substantial questions of law arising, my lords. And I request my lords to kindly add. There's 4 substantial questions of law, my lords, which should be at page number 8 and 9.
The appeal has already been admitted. Similar questions.
Please, my lords. Issue pertaining to transfer pricing, my lord.
Dilip Kumar Lanet. Have you heard on the question of admission? 4 questions.
My lords, 15, my lords, we've raised 6 substantial questions of law, my lords. All these, my lords, 13 to 17, it all pertains to transfer pricing issues only, my lords. We've raised 6 questions in this appeal, my lords. Case number 9, 10, and 7, my lords. All 6 requires to be admitted, my lords.
How many questions you are proposing?
6, my lords. My lords, 1, 2, 1, 2, 4, and 6, my lords.
1, 2, 4, and 6. Right?
Please.
1, 2, 4, and 6.
Petitioner, original petitioner, the amendment type.
Number 16, KV Arvind.
My lords, in this, we've raised 2 substantial questions of law at page number 8 and 9, my lords. Lord, this is, we've raised 4 substantial questions of law, my lord. It is pertaining to the common order, my lord, that's serial number 14, my lord. Serial number 14 and serial number 16, it's a common order, my lord, challenging two separate assessment years. 4 substantial questions of law we've raised, my lord.
Following purpose.
Publish.
Number 18, Sri M.V. Sundarala, Srimati Leela Rani HP.
My lords, I'm appearing for the petitioner in this matter. My lords, I seek 2 weeks' time since the parties are still settling the matter, my lords. We will report the settlement after 2 weeks. The last few days, the parties have not been able to settle. The settlement talks have slowed down because of this whole COVID.
Last date also, 30th November, also you sought adjournment on this ground.
Yes, my lords, I understand.
30th November.
Yes. Yes, my lords. However, the parties are saying that they have been settling the matter.
No, they haven't settled means then argue.
My lords, we can argue on the next date if it's not settled. We suggested the same to the party today.
Please be clear that next date you be ready. Don't have any.
Please, my lords.
Since November, we are in January. January is about to be over.
I understand, my lords.
After present, Learned Counsel for the petitioner once again pay for adjournment in order to enable them to report settlement. On 8/11/2021 as well as on 30th/11/2021. Adjournment was sought on similar grounds. However, by way of indulgence, 2 weeks further time is granted. Enable the
Much obliged, my lords.
settlement, in which the matter shall be heard.
Please. Much obliged, my lords.
Serial number 19, my lords, may appear for petitioner.
I appear for respondent number 2, my lord. Lord, respondent number 1, bank counsel is infected by COVID. So he requested me to seek 2 weeks time, my lord.
Yes, my lords.
It's stated at the bar that the counsel for respondent number 1 is unwell in view of official submission list after 2 weeks.
Much obliged, my lord.
Obliged.
21, Sri Vasu Kevi, party pastor.
How much time? Oh.
I appear for respondent, please.
Yes. This party is praying for time.
Yes, my lord. No.
Because pay for adjournment list after 2 weeks.
Great.
Number 24, Srimati Tanmay Rajkumar.
Lords, I appear for the appellant. My Lords, Senior Advocate Mr. Padiwala has engaged in this matter. My Lords, could it be taken up on 22nd February? The reason is this, my Lords, this matter requires physical consideration.
Case for adjournment on the ground that the matter has to be argued by the party one. Therefore, in outstation counsel, we go to case for adjournment. List on 22nd.
Much obliged.
22.
Number 25, Sri K.V. Arvind, Sri Narendra Kumar Jain.
My Lord, serial number 25, my Lord, this matter pertains to transfer pricing, my Lord. I request my Lords to kindly defer it by 3 weeks, my Lord, after disposal of the Honorable Supreme Court. This matter we can, because there's other batch.
Raise for adjournment on the ground that the issue involved in this appeal is pending adjudication before the Supreme Court. In view of aforesaid permission, list after 3 weeks.
26, Sri K.V. Arvind, Sri Arvind V. Chavan.
Lords, 26, my Lords, it can be taken up next week, my Lords.
Raise for adjournment. This makes sense.
Number 28, CH Sanmati, Sri V. Chandrasekhar.
Appear for appellant, my Lord. Ready, my Lord.
Ready?
Yes, my Lord.
My Lord, Chandrasekhar for the respondent, we need to hand over the case law compilation both to the other side as well as file it to the court. I will do it in the course of the day. Matter may be taken up day after tomorrow, my Lords.
27th then.
Please, my Lord.
Okay.
27 January.
Much obliged. Much obliged, my Lords.
CI Sanmati Learned Counsel for the Revenue, Mr. V. Chandrasekhar, Learned Counsel for Respondent, raise for short accommodation in order to enable him to file a case law compilation. List on 27 January 2022.
Much obliged.
Much obliged.
Number 30, Srimati Tanmay Rajkumar, Sri K.V. Arvind.
Yes, madam.
I appear for the appellant, my Lords.
Yes, madam.
My Lords, this also pertains to transfer pricing, my Lords. It has to be deferred, my Lords. This serial number 30 also pertains to transfer pricing issues, my Lords.
Yes, madam.
My Lords, the issues do pertain to transfer pricing. Only thing, my Lords, the issues are not identical to the batch that is there before the Honorable Supreme Court. I have no objection to the matter being adjourned, my Lords, but let it not be recorded as being deferred to await the outcome of the Honorable Supreme Court's order.
Mr. You should examine Mr. Dilip. They have been saying this for quite a while. We remember that each and every case you say transfer pricing. What they say is, you should tell us what is the issue pending before Supreme Court and what is the issue involved in this appeal. At least tell us that, right?
Can we make this next week?
Counsel, mark her presence, Learned Counsel for the Revenue, praise for adjournment. This after 1 week. Okay. 1 tip.
Matter, number 6, Sri K. Chandrasekhar, Sri Madhukar.
Please, Your Lordship.
Yes, yes.
Petitioner is the daughter of the detainee who has been detained under Coffee-Posa by an order passed by the respondent number 2. On the earlier occasion, Your Lordship would recollect a similar matter relating to the son had come up before Your Lordship, and Your Lordship had disposed of the matter. The contention, Your Lordship, the order of detention on the basis of
in SLP. Mr. Javli, what happened in SLP?
That is pending, Your Lordship. The issues that I am raising in this content in this petition were not the grounds on which the earlier petition had been disposed of by Your Lordship.
1 minute, 1 minute. been ordered the detention to be precise. Yes, please.
Your Lordship, the order of detention under which he has been detained is found at page number 27, annexure E. In support of the order, as required at law, the grounds of detention have been furnished, which commences at annexure F of page 29. Page 29, annexure F. And to derive the subjective satisfaction to pass an order of detention, the detaining authority has provided to the detainee the list of documents on which reliance was placed, which is at annexure G, page 40. "614 pages of records are purported to have been considered by the empowered officer to derive subjective satisfaction to record the grounds of detention in support of the order of detention." Now, Your Lordship, what I am trying to submit here before Your Lordship is that if he derived a particular satisfaction based on records placed before him, then those in accordance with the law laid down would constitute being relied upon documents and are required to be furnished to the detainee pari passu the grounds of detention. Being a document on the basis of which he derived satisfaction to make a particular recording would be required to be furnished to the detainee along with the grounds of detention. Your Lordship, now I have raised, Your Lordship may kindly see page 31, paragraph 15. Bottom of the page. Page 31, Your Lordship finds it. On perusal of various documents recovered from the file submitted by Gurmeet Singh Kohli, wide your letter dated 6/2020. It is observed that Gurmeet Singh has been a party to the following cases booked by different statutory authorities from time to time. A case has been booked by the Additional Commissioner of Customs Air Cargo Complex, Export New Customs House, Gurmeet Singh, for using or causing to be used for documents and DPB license obtained on fraud and forgery. In respect of the said investigation, Gurmeet Singh went in appeal against the order passed by the adjudicating authority, which was rejected by the commissioner. Now, this particular averment has been made by the detaining authority in the grounds of detention. My contention is, where are the documents to derive this satisfaction? Get out in the list of documents, page numbers 40 in annexure G. The contention in this regard has been raised by me in para number 29 to 36. Para number 29 to 36. I have specifically raised this. Now your lordship will find that they have filed their statement of objection, wherein this paragraphs have been dealt at para 30 on page 22 of the statement of objection. Para 30, page 22. Your lordship will notice that they don't touch this issue at all. It has been placed, it has been considered. This is at page number so and so of the relied upon documents. No such answer is forthcoming there. So the answer would now be that documents on the basis of which you derived satisfaction have not been furnished to me. That would be the only conclusion one would arrive at. Similarly, your lordship, at para number 22 on page 10 of my petition, para number 22, page 10, I have made an averment that truncated documents have been furnished to me. And more particularly at page 330 to 331 of the relied upon documents. This has been met at para number 27, page 19 of the statement of objection. May I take your lordship to para 22 and 23?
Yes.
The order of detention is vitiated in the satisfaction of the authority was arrived at on a truncated document, pages 330 and 331 of the relied upon documents. The detaining authority has recorded subjective satisfaction at page 4, para 15E of the grounds of detention that the detainee has been penalized under section 114 of the Customs Act 1962. The satisfaction is purportedly based on documents provided as relied upon documents at page 33 to 31. However, examination of those documents reveals that the same is in a truncated fashion and is not the complete document. The existing document does not derive the satisfaction as recorded under the purported reference status. Consequently, the detainee having not been furnished the relied upon documents and or the detaining authority having not applied his mind reveals a slipshod manner of exercise of powers affecting the subjective satisfaction, and consequently the detention of the detainee is affected. Now, your lordship, in the entirety of the grounds of detention, and for quick purposes, I will take your lordship to page number 30. Page number 30 of the grounds of detention. Your lordship will see paragraph number 4 on the top of the page. Considering the gravity of the offence committed by Yatish Raju, CHA for Terrain Overseas India, so and so, in the light of the statement above, he was arrested on 2/1/2020 under section 104 of the Customs Act and produced before the Honorable Court, along with applications for remand of the arrested accused under 135 of the Customs Act. The judicial magistrate remanded the arrested accused and Yatish Raju was lodged in the Central Prison, Bangalore. I don't find a single piece of paper relating to this satisfaction in the entirety of 614 pages. The remand application is not there. The arrest memo is not there. The order of the judicial magistrate is not there. Then where did he get these material from? That means that material or documents taken into consideration for purposes of formulation of the grounds of detention have not been furnished to the detainee. The entirety of the petition, Your Lordship, I am concentrating before Your Lordship exclusively on the ground that if you have detained me, kindly provide me those documents on the basis of which you derive subjective satisfaction. Now, Your Lordship, the entire petition I can go on reading and showing paragraphs after paragraphs. However, Your Lordship, I'll take Your Lordships directly to the law, and that is, Your Lordship, I have given a compilation of the decisions. Your Lordship finds the compilation.
Yes.
Compilation of decisions.
Yes, yes. Yes.
The first decision is of the Supreme Court in Ichu Devi's case, AIR 1980, Supreme Court 1983. It is that it commences at paragraph page 12 of the compilation.
Yes.
Your Lordship, I will skip that and take Your Lordship straight to page number 15. Page 15, paragraph 3. There were several grounds on which the detention of the detainee was challenged in the petition. But it is not necessary to refer to all the grounds, since there is one ground which, in our opinion, fatal to the continued detention of the detainee, and it will be sufficient if we confine our attention to that ground. The contention of the petitioner under this ground was that those several statements and documents were relied upon in the grounds of detention, and considerable reliance was also placed on 2 tape-recorded conversations in the grounds of detention, the detaining authority did not serve on the detainee, along with the grounds of detention, copies of those statements, documents, and tapes. Could therefore be said that the grounds of detention were duly served on the detainee required under subsection 3 of section 3 of the Coffee-Posa Act and clause 5 of article 22 of the Constitution. The petitioner urged that the subsection 3 of section 3 of the Coffee-Posa and clause 5 of article 22 of the Constitution required that the detaining authority should as soon as may be communicate to the detainee the grounds on which the order of detention has been made, and such grounds would compromise not merely a bare recital of the grounds of detention, but also all statements and documents relied upon in the grounds of detention, because these later would also form part of the such grounds. It was also contended by the petitioner in the alternative that in any event the detaining authority was bound to give copies of the statement, documents, and tapes relied upon in the grounds of detention to the detainee without any avoidable delay, in order that the detainee should have the earliest opportunity of making an effective representation against the order of detention. The argument of the petitioner was that in the present case, though the detainee asked for the copies of the statement, documents, and materials relied upon in the grounds of detention, the detaining authority did not supply copies of such statements, so and such. Now, Your Lordship, the relevant thing comes to it. Your Lordship may take to page number 16 on the right, left-hand side. Page 16 on the left-hand side. Encroachment on personal liberty, and it is the solemn duty of the courts to ensure that the power is exercised strictly in accordance with the requirements of the Constitution and the law. The court should always lean in favor of upholding personal liberty, for it is one of the most cherished values of mankind. Without it, life would not be worth living. It is one of the pillars of free democratic society. Men have rightly laid down their lives at the altar in order to secure it, protect it, and preserve it. The Constitution has therefore, while considering the power of preventive detention, provided procedural safeguard with view to protecting the citizens against arbitrary and unjustified invasion of personal liberty, and the courts have always zealously tried to uphold and enforce these safeguards. The court has through its judicial pronouncement created various legal bulwarks and breakwaters into the vast powers conferred on the executive by the laws of preventive detention prevalent at different points of time. It is true that sometimes even a smuggler may be able to secure his release from detention if one of the safeguards or requirements laid down by the Constitution or the law has not been observed by the detaining authority, but that can be no reason for whittling down or diluting the safeguards provided by the Constitution and the law. If the detaining authority wants to preventively detain a smuggler, it can certainly do so, but only in accordance with the provisions of the Constitution and the law. And if there is a breach of such provision, the rule of law requires that the detainee must be set at liberty, however wicked or mischievous he may be. The law cannot be subverted, particularly the area of personal liberty, in order to prevent a smuggler from securing his release from detention, because whatever is the law laid down by the court in the matter of a case of a smuggler would equally be applicable to the case of preventive detention under any other law. This court would be laying down a dangerous precedent if it allows a hard case to make bad law. We must therefore interpret the provisions of the Constitution and the law in regarding to preventive detention without being in any manner trampled by the fact that this is a case where a possible smuggler is seeking a release from his detention. Now, Your Lordship. Your Lordship may take to page 17. In between, Your Lordship, the true meaning and import. Your Lordship finds it on the right hand side. The true meaning and import of clause 5 of Article 22. Your Lordship finds it. Yes. After that, the constitutional imperatives enacted in this article are twofold. The detaining authority must, as soon as may be, that is, as soon as practicable after the detention, communicate to the detainee the grounds on which the order of detention has been made. And 2, the detaining authority must afford the detainee the earliest opportunity of making representation against the order of detention. These are the barest minimum safeguards which must be observed before an executive authority can be permitted to preventively detain a person and thereby drown his right of personal liberty in the name of public good and social security. It will be seen that one of the basic requirements of clause 5 of Article 22 is that the authority making the order of detention must, as soon as may be, communicate to the detainee the grounds on which the order of detention has been made, and under subsection 3 of section 3 of the Copy Posa Act, the words as soon as may be has been translated to mean ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing, not later than 15 days from the date of detention. The grounds of detention must therefore be furnished to the detainee ordinarily within 5 days from the date of detention, but in exceptional circumstances and for reasons to be recorded in writing, the time for furnishing the grounds of detention may stand extended, but in any event, it cannot be later than 15 days from the date of detention. These are the two outside time limits provided under section 3 of the Copy Posa Act, because unless the grounds of detention are furnished to the detainee, it would not be possible for him to make a representation against the order of detention. And it is a basic requirement of clause 5 of Article 22 that the detainee must be afforded the earliest opportunity of making a representation against his detention. If the grounds of detention are not furnished to the detainee within 5 days or 15 days, as the case may be, the continued detention of the detainee would be rendered illegal both on the grounds of violation of clause 5 of Article 22, as also on the ground of breach of requirement of section 3, subsection 3 of the Coffee Post Act. Now it is obvious that when clause 5 of Article 22 and subsection 3 of section 3 of the Coffee Post Act provide that the grounds of detention should be communicated to the detainee within 5 or 15 days, as the case may be, what is meant is that the grounds of detention in their entirety must be furnished to the detainee. If there are any documents, statements, or other material relied upon in the grounds of detention, they must also be communicated to the detainee, because being incorporated in the grounds of detention, they form part of the grounds, and the grounds furnished to the detainee cannot be said to be complete without them. It would not therefore be sufficient to communicate to the detainee a bare recital of the grounds of detention, but copies of the documents, statements, and other material relied upon in the grounds of detention must also be furnished to the detainee within the prescribed time, subject, of course, to clause 6 of Article 22, in order to constitute a compliance with clause 5 of the Article 22 and section 3 of. One of the primary objects of communicating the grounds of detention to the detainee is to enable the detainee at the earliest opportunity to make a representation against the detention, and it is difficult to see how the detainee can possibly make an effective representation unless he is also furnished the copies of the documents and other material relied upon in the grounds of detention. There can therefore be no doubt that on a proper construction of clause 5 of Article 22, it is necessary that the valid continuation of the detention, that subject to clause 6 of Article 22, copies of the documents, statement, and other material relied upon in the grounds of detention should be furnished to the detainee along with the grounds of detention. And in any event, not later than 5 days, and in exceptional circumstances for reasons to be recorded, not later. If this requirement is not satisfied, the continued detention of the detainee would be illegal and void. Now, in this case, Your Lordship, I have drawn Your Lordship's attention that those documents have not been furnished. Now, Your Lordship, one other contention that I have raised is, Your Lordship will notice on page 32, on page 36, on the top of the page, there's a chart. Your Lordship will see item number 12.
What is the contention?
Contention is that such a document does not exist. None of these shipping bills. What is the case of the department? Case of the department is that he has been going on filing bill of shipping bills, exporting goods by overvaluing it and not realizing the export proceeds. This is the basic allegation. In short, in 3 sentences, as I may put it, the shipping bills have been filed for purposes of export. Overvaluation has been done. Export proceeds have not been realized. And this has all been with an attempt to make illegal gain of the drawback scheme or the duty exemption passbook scheme. This is the sum and substance of their entire case. Now, the question that arises for this court and in the context of the order of detention is, should those shipping bills not be placed? Basic entire case of the prosecution or the department is that he is exporting it illegally. The shipping bills, the basic document on the basis of which an export takes place, has not been placed. Two things arise out of it. One, was it a shipping bill or was there an export at all? Item number 1. 2, even assuming for an export, was the shipping bill for a claim of drawback? Not all shipping bills are claimed for drawback. There is a special shipping bill that has to be filed if you are claiming a drawback. Now, that could be known only by seeing the document. If that document itself is not being placed, then as laid down by the Honorable Supreme Court, vital and necessary material would have affected the mind of the detaining authority having not been placed or considered, vitiates the order of detention. And in that regard, I am placing reliance on the judgment in this compilation at page number 1. Page number 1. Asha Devi versus K. Shivaraj. Left-hand side, first head note. It is well settled that the subjective satisfaction requisite on the part of the detaining authority, the formation of which is a condition precedent to the passing of detention order, will get vitiated if material or vital facts which would have a bearing on the issue and would influence the mind of the detaining authority one way or the other are ignored or not considered by the detaining authority issuing on the order of detention.
Yes.
Then your lordship may go to page 6 of the compilation.
Basically, these are your two contentions, right?
These. Vital material required to be placed, having not been placed, affects the detention. Requisite grounds or averments made in the grounds of detention, which reveals taking into consideration of certain documents to derive that subjective satisfaction, have not been. And this entire compilation of decisions that I have placed before your lordship is law on that regard. And I will take only one more minute, your lordship. Page number 6 of this compilation. In the case of Ganga Ramchand Bharwani. Your lordship may just read that head note. The constitutional imperatives enacted in Article 22(5) of the Constitution are twofold. If the detaining authority must, as soon as may be, as soon as practicable after the detention, communicate to the detainee the grounds on which the order has been made, and if the detaining authority must afford the detainee the earliest opportunity of making a representation against the order of detention. In the context, ground does not merely mean a recital or reproduction of a ground of satisfaction of the authority in the language of section 3, nor is it restricted to a bare statement of conclusion on facts. Nothing less than all the basic facts and materials which influence the detaining authority in making the order of detention must be communicated to the detainee. The mere fact that the grounds of detention served on the detainee were elaborate does not absolve the detaining authority from its constitutional responsibility to supply all the basic facts and materials relied upon in the grounds of detention. Your lordship, that is that para number 16, which is your lordship will find at page page 10.
Yes.
Now, your lordship, one other decision on this compilation which I would like your lordship to draw attention is at page 94 of the compilation. Serene Dolkar. Paragraph 12, your lordship. It should be at page number 97. The learned additional Solicitor General relied upon the feature that the petitioner's wife knew both English and Tibetan language, and a defective representation as a fact has been made. There can be no two opinions that the requirement of law within the provisions of Article 22(5) of the Constitution is that the detainee has to be informed about the grounds of detention in a language which he understands. The fact that the detainee's wife knew the language in which the grounds read does not really satisfy the legal requirement. reliance was placed by the learned additional solicitor Prakash Chandra Mehta in support of his contention that unless the detainee was able to establish prejudice on the account of the fact that the grounds of detention, the documents accompanying were not in a language known to the detainee, the order would not be vitiated. There is no clear indication of the test of prejudice being applied in that case. On the facts relevant before the court, a conclusion was reached that the detainee was merely feigning ignorance of English and on that putting he knew English the matter was.
Test of prejudice cannot be applied to a case of preventive detention.
Prejudice is not the issue.
Yes.
Please, Your Worship. In AIR 1963 Supreme Court, of course, I have not provided this, Your Lordship. AIR 1963 Supreme Court, page 43. I'll just read one paragraph in Haribandhu Das case. Negligence or inaptitude of the
which para? Which
paragraph number 11.
Yes.
Yeah, I'll just read it out. Negligence or inaptitude of the detaining authority in making the defective order or in failing to comply with the mandatory provisions of the Act may in some cases ensure to the benefit of the detainee to which he is not entitled. But it must be remembered that the Act confers power to make a serious invasion upon the liberty of the citizen by the subjective satisfaction of facts by an executive authority, and the Parliament has provided several safeguards against misuse of the power. The very fact that a defective order has been passed or that it has become invalid because of negligence on the part of the detaining authority and the principles underlining section 13(2), in our view, the outcome of insistence of the Parliament that the detaining authority shall fully apply its mind and comply with the requirements of the statute and of restraint upon refusal to countenance slipshod exercise of power reveals slipshod exercise of power. So my humble submission here is that this detention order has to be quashed by Your Lordship on the ground that documents which influence the mind of the detaining authority in passing the order of detention and recorded in the grounds of detention have not been furnished to the detainee pari passu the grounds of detention. Once it has not been furnished to the detainee along with the grounds of detention, his right to make an effective representation as provided in the Constitution Article 22(5) stands vitiated and requiring the detention to be quashed. This is my sum and substance of this.
Yes, my lord. Yes, my lord. My lord, the two submissions have been made by the learned senior advocate, my lord. The first submission is that document was not submitted to the detainee. That is first submission. And part of that particular submission, a truncated document was furnished to him. That is part of the same submission, my lord. The second submission was that vital material facts and documents were required to be considered by the authority. Those documents were not considered, and therefore the reference made in the order is not proper, and those documents were also not furnished to me, and therefore the entire proceedings is vitiated. These are the two submissions which has been made by the learned senior advocate, my lord. I would like to make my submission to with respect of these two submissions. My lord, I request my lords to kindly take the grounds of detention. Grounds of detention, my lords would find at Annexure F, page number 29. May I, my lord?
Yes.
It starts like this, my lord. The sponsoring authority has placed the facts before the authority, my lord, and it reads like this, my lord. After subject, it reads like this. The following facts have been brought to my attention by the sponsoring authority of this COFEPASA proposal, that is the Directorate of Revenue Intelligence, Bangalore. And I have gone through the facts presented by the sponsoring authority as mentioned below. So these are the facts, my lord. It starts from Roman number 1 and it continues up to page number 34, my lord, up to para number 19, my lord. My lord, during investigation, my lord, I request my lords to kindly take page number 31, my lord, para number 13, Roman 13, my lord. Page number 31, para number 13, Roman 13, my lord. Hope my lords got that particular para number 13.
Yes.
Here, my lord, during the investigation, my lord, that from the detinue, mobile was seized, my lord. 3 mobiles were seized. From his mobile, my lord, various orders passed against him, passed against the shell company, my lord, which are created by him and his son. Those orders were took out. Then, my lord, considering that particular aspect at para number 15, my lord, there is a reference to the various quasi-judicial orders which has been passed against them. That is para number 15, A to H, my lord. These are the various orders, notices which has been issued by the various authorities. Then, my lord, I request my lords to kindly come to page number 34, my lord. At page number 34, my lord, on the basis of the statement recorded, statement of the agent recorded, on the basis of the various quasi-judicial orders which have been passed, my lord, the sponsoring authority has placed the various facts before the authority. Authority has made this particular observation at para number 20, my lord, Roman number 20, page number 34. I will read it like this, my lord. It reads like this, my lord. Based on the aforementioned parameters, a total 14 companies have been identified as being operated, controlled by Sri so-and-so, that is you, and your son so-and-so. The name of the companies were as follows. These are the 14 companies which are shell companies, my lord. This is our first submission. This is first ground, my lord. Then, my lord, with respect of these 14 companies from para number 20, my lord, what is the parallel investigation was conducted by the DGGI Mumbai, that has been narrated, my lord, where the merger has been conducted, whether it is a shell company or not, that has been ascertained. Then, my lord, I request my lords to kindly come to page number 35, my lord. Page number 35, para number 21. Here, my lord, in this particular para number 21, on the basis of the statement recorded, on the basis of the details relating to the shell companies, what is the loss, what is the freight on board value, and how these particular company, 14 companies, have fraudulently claimed the duty drawback has been explained, my lord. Then, my lord, I request my lords to kindly take, my lord, page number 36. Hope I am audible, my lord. Sorry, my lord. Yes, my lord. Yes, my lord. My lord, at page number 36, my lord, after referring to all these things, my lord, then, my lord, what is emerges from the investigation, that has been explained at page number 36, my lord. In para number 23, my lord, there is a hanging paragraph in which there is a specific statement, creation of shell companies and receiving duty drawback fraudulently, then shipping bills which are created by them. And the contention of the senior counsel is that I am supposed to produce the shipping bills, but there are a quasi-judicial orders have been passed. It is a shell company, and with respect of that only I have realized that this is particular shipping bills, everything are created, and these companies are also created for the purpose of receiving the fraudulent duty drawbacks. Then, my lord, it continues at page number 37, my lord, how I have conducted appreciated the investigation, how I have formed the opinion, all those things I have explained in page number 36, 37, my lord. Then, my lord, at page number 38, from numerical number 2, my lord, I have given my observations, I have given my finding, why this detention order is to be passed. Then, accordingly, from numerical para number 2 to 10, my lord, I have given the reason why this particular arrest order has to be, the detention order has to be passed. The contention is that I'm supposed to look into one particular document. I have not seen those documents, or I have not produced that particular document, or that has not been relied upon, it is a material fact. No, that is not the shipping bill is not the material fact. Shipping bill is one part of the various allegation. The major allegation is that shell company fraudulently withdrawing the duty drawback, overvaluation. These are the various aspects. And there are quasi-judicial order. When the quasi-judicial order has been passed, which has been retrieved from the mobile of the detainee itself, then my lord, those documents I can look into. And on that basis, I can formulate my opinion. And accordingly, I can come to a conclusion. And that particular fact with respect of seizure of the mobile, it is not disputed. These quasi-judicial orders are not disputed. Only contention is that I should have looked into some other document. When there is a quasi-judicial orders, why I am supposed to look into the other material documents? When there is a definite finding has been given by the quasi-judicial authority and which has been recovered from the mobile of the detainee itself. And the detainee has approached the appellate authority also. Appellate authority has rejected his contention. Now he is supposed to give the explanation. Now I request my lords to kindly take page number 40, my lord, of the petition compilation. Hope my lords got the page number 40.
List of documents. List of relied upon documents. 40.
Please, your lord. Please.
Yes, my lord. Page number 40, my lord. Annexure G, my lord. Annexure G, my lord.
Yes.
Here, my lord, the first document is with respect of copy of IEC code of one particular company, my lord. Then, my lord, merger which has been conducted. Serial number 2 is the merger, my lord. Then serial number 6 is the merger. Serial number 7 is the merger. Serial number 10, 11. Then my lords can find at serial number 20 as well as at serial number 22, 23, my lord. These are all the merger with respect of these companies. And we have conducted the merger. Spot inspection has been done, whether these companies are in existence or not. Then, my lord, then my lords, there is a statement of the agent, that is the CH agent. His statement has been recorded. That is at serial number 3, serial number 4, and those statements are the part of the relied upon documents. Then, my lord, serial number 21, my lord, that is very important, my lord. That is documents retrieved from the forensic examination of mobile device submitted by Sri Gurmeet Singh Kohli, that is the detainee, my lord. From his own mobile, we received all the quasi-judicial orders passed by the various authorities. So with these documents, my lord, I have formed the opinion and accordingly I have passed the detention order, my lord. So my submission is that there is no satisfaction, or I have not looked into the vital document that does not hold good, my lord. The reason is that I have looked into the quasi-judicial order. I have made a spot inspection of the places. I have collected various documents. I have received the statement of appropriate persons. On that basis, I have come to conclusion that these are the shell companies and there is a fraudulent withdrawal of duty drawback and they have overvalued the amount, my lord. Then, my lord, there is second contention. I will make my submission with respect of the second contention, my lord. That is, the documents were not supplied, my lord. A statement has been made in the petition that, my lord, the detainee was arrested at Bombay. That is factually incorrect, my lord. He was arrested at New Delhi, my lord. And for that purpose, my lord, I have produced the boarding pass itself, my lord, from where he boarded the plane, my lord. Then, my lord, on 19th September 2021, my lord, the copy was served on him along with my statement of objection, my lord. I have produced this particular mahajar. Mahajar was drawn while serving the copy on him, my lord. In that particular mahajar, my lord, the service of the document and total 614 pages of the document which has been served upon him, and he has also signed at page number 35 saying that I have received the documents. His contention is that the jail authority has not signed this particular document. No, he was arrested at his residence in New Delhi, and at that particular place it was served on him, and that particular service is acknowledged by him, and the merger also has been drawn. And to overcome this particular merger, my lord, he addressed one more letter saying that I have not received the document. We made it clear that we have already served the original documents.
Which page?
Sorry, my lord, sorry. Page number 33, my lord. Page number 33 of my statement of objection, my lord. Hope my lords received the page number 33 is available in the statement of objection, my lord.
Yes, yes.
That is merger, my lord. Yes, my lord. The last page of that particular document is page number 35, my lord. The merger was drawn on 19th September 2021, my lord. It started at 11:30, my lord, in New Delhi at Vishal Enclave, Rajouri Garden. And that merger work continued up to 1:30, my lord. Then typing all those things completed, and thereafter the copy was served upon him. I had 5 days time to serve all the documents, but on the same day I have served the copy to him. And he has signed and he has received the documents on the same day itself. Page number 35, my lords would find the handwritten Shara as well as signature of the detainee. At the bottom, my lords would find. And it is also, the witnesses are there, my lord. The witnesses are there and officers have signed it. And each page of the detention order, each page of the relied upon documents, he has signed it saying that he has received the document in all the 614 pages.
That is not the case, Mr. Deshpande, in fact. That is not the case.
Yes,
he doesn't say that
yes,
whatever documents you relied upon has not been supplied. That is not the case of the detainee. Detainee says that you have formed certain opinion on the basis of the documents which were not supplied to the detainee. That's what he has read, you know. You have heard him say. So he has, I mean, he is not denying
he has
certified that he has not received the documents. That is admitted. He has received the documents which is mentioned at page 33.
If that is the submission, my lord, if it is an admitted position, my lord, I will not make submission with respect of that. My only
yes.
The
So
document what I am contending does not form part of pages 1 to 614 is my contention.
Yes. Yes.
The satisfaction is not as recorded in the grounds. How he derived that satisfaction, material that is stated in those paragraphs do not find place in 614 pages.
Yes.
That is my case.
Yes, Mr. Deshpande.
Yes, my lord. My lord, with respect of that, my lord, my submission is that, my lord, my contention, my ground of detention is that shell companies are created. 14 shell companies are created. For that, my lord, the merger is the basis. All the mergers are placed on record, and it is relied upon documents. Those mergers are available. Then, my lord, my one more grounds of detention is that there is a fraudulent duty drawing back that has been done by this particular detainee along with his son. With respect of that, my lord, there are various quasi-judicial orders are there which has been retrieved from the mobile phone of the detainee, and that is also part of the relied upon documents. That particular relied upon document is page number 329 to page number 413. And then, my lord, the statement of the agent and statement of the agent has been considered with these shell companies as well as the documents retrieved from his mobile phone, and all those orders are the quasi-judicial orders. This is our submission, my lord, with respect of the satisfaction.
That is?
Yes, yes.
Yes, sir.
Your lordship may go to page number 36 of the grounds of detention. Page 36. Para number 23. Your lordship finds that during investigation, the role of Gurmeet Singh you have emerged as under. Each one of these paragraphs is a satisfaction of the authority. Particularly 23B. Gurmeet Singh and Amarpreet appear to have willfully and intentionally misdeclared the description and value of the exported goods as Indian handmade silk carpet. Where do we get this material? Then you know, Gurmeet Singh filed multiple shipping bills declaring the price do not reflect the actual value and have been grossly overvalued to be Indian knitted silk carpet. Again, nothing. Then on page 37D, rendered themselves ineligible for the drawback claims amounting to 1.83 crores. On page 37, each one of these paragraphs, Your Lordship, I am not for a moment saying detention order cannot be passed. I am not for a moment saying that the order is to be done in a particular fashion. My only contention is you derive a satisfaction, justify it with certain documents. If there are no documents, that means documents which influence your mind have not been furnished. One other decision I would like to just draw your Lordship attention in my compilation is at page 35. Page 35. Page 35. Page 35, Your Lordship.
Yes.
Yeah. O.P. Rana, Learned Counsel for the State of Maharashtra, urges that the copies of the documents were not supplied to the detainee, as the detainee was already aware of the contents of the documents. That is hardly any answer to the submission made on behalf of the detainee. The detainee was entitled to be supplied with copies of all material documents instead of having to rely upon his memory in regard to the contents of the document. The failure of the detaining authority to supply copies of such documents vitiates the detention. This is also reiterated at page 38, Your Lord. Sunil Dutt case, particularly the paragraph 4. The same law has been reiterated in all these judgments, Your Lordship. It's the same principles. I could keep on reading it, but it is the same thing again and again. What it says is, once it has been incorporated by reference in the grounds, it has to be furnished. That is the sum and substance of all these decisions. So my humble submission here is that documents which have influenced your mind having not been furnished has vitiated the order of detention. Second thing is that the Learned Counsel for the State drew attention that these are all documents withdrawn from your mobile. That is what they are trying to say. Now, the question that arises is, and particularly with reference to page number 330 and 331 of the relied upon documents, what I have said is, yes, you relied upon 330 and 331 of the document. Agreed. However, kindly see those 330 and 331. It is the first page and the last page. Where do you get all the material inter se? What took place in between is not there. Truncated documents have been looked into. It's like reading your Lordship's decision of the first page, the cause title, and the last page where your Lordship has signed. And then say that this is the judgment of the Lordships and I am going to rely upon. First page and last page. And that too not proper. So my humble submission here is, they have not disputed that fact. Similarly, on page number 334 of the document, I have made specific reference in the grounds. They don't deny it. So my humble submission here is, for having not furnished relied upon documents, all other contentions I have not raised, Your Lordship. Those issues are contentious. I will not waste Your Lordship's time. So pray that the detainee be released.
My lord, with respect of his son, my lord, the already order has been passed, my lord, by this honorable court, and
that he told.
Same contention was urged, my lord.
No, I have not. With due respect, none of these contentions have been urged there. Let that not be a factual mistake.
Yes,
sorry, my lord.
I take serious objection to that.
No, one like this.
Please.
Yes. Okay. That's it.
No, they are not open the seat. We'll have to close. Open ಮಾಡಿದ್ದಾರೆ.
ರಮೇಶ್ ಮಾಡಿ
ಸರ್ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಸರ್
ಇವತ್ತು ಪಾಸ್ ಮಾಡ್ತಾರೆ ಸರ್ ಆರ್ಡರ್ ಸರ್ ಇವತ್ತೇ ಮಾಡ್ತಾರೆ. ಹಾ ಮಾಡ್ತಾರೆ. CGC ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಇದ್ದಾರೆ. ಆ ಕಡೆ ಕಿರಣ್ ಎಸ್ ಅವಳಿ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಚಂದ್ರಶೇಖರ್. ಆಮೇಲೆ ತೇಜಸ್ವಿ HCGP R3ಗೆ 1 and 2ಗೆ ಅವರ